In this video, we would like to discuss residuary powers of legislation as provided under Article 248 of the Constitution. So, the very provision under Article 248 reads as subject to Article 246A, which deals with special provision with respect to goods and services tax. So, Parliament has exclusive power to make any law with respect to any matter not enumerated in the concurrent list or state list. So, this is a kind of exclusive power that is provided to Parliament to make law in regards to any subject which is not found mentioned in concurrent list or state list as provided under clause 1 of Article 248. And in clause 1, the very provision that subject to Article 246A, which relates to special provision with respect to goods and services tax or GST, in short, which was inserted under Constitutional 101st Amendment Act 2016, and clause 2 of Article 248 provides that such power shall include the power of making any law imposing a tax not mentioned in either of those lists. So, this is a kind of taxing power. So, the very constitutionality of Wealth Tax Act was raised in the leading case Union of India versus Harbhajan Singh Dhillon in 1972, where the Supreme Court held that the nature of the wealth tax imposed under the Wealth Tax Act as originally stood was different from that of a tax under entry 49 list 2, and that is state list, and it did not fall under this entry. However, assuming that the Wealth Tax Act originally enacted is held to be legislation under entry 86 list 1, that is the union list, there is nothing in the Constitution to prevent Parliament from combining its power under entry 86 list 1, that is the union list, with its power under entry 97 list 1, which is also the union list, as it was pronounced by the Supreme Court in 1972 in this leading case, Union of India versus Harbhajan Singh Dhillon. And now we will go to another important part of residuary power is residuary power of legislation as it was pronounced In the leading case, National Mineral Development Corporation Limited versus State of Karnataka in 2016 by the Karnataka High Court, as it was pronounced, the Parliament has the power to legislate with respect to a matter in the state list in 7th schedule of Constitution in national interest by invoking Article 249 of the Constitution. If there is inconsistency between the laws made by the Parliament and the laws made by the state legislature with regard to any subject enumerated under the concurrent list, the same is resolved under Article 254 of the Constitution, as it was pronounced by the Karnataka High Court in this important leading case. National Mineral Development Corporation Limited versus State of Karnataka. And now we'll go to another important aspects of residuary power, that is non-availability of residuary power, as it was held by the Supreme Court in 2013 in the very important leading case, that is Lily Thomas versus Union of India, where the Supreme Court held that the legislative power of Parliament to enact any law relating to disqualification for membership of either House of Parliament or Legislative Assembly or Legislative Council of the state can be located only in Articles 102 Clause 1 and Article 191 Clause 1 of the Constitution, and not in Article 248 of the Constitution, as it was held by the apex court in this important leading case, Lily Thomas versus Union of India. And now we'll go to Article 249, which relates the exclusive power of Council of State or Rajya Sabha, which provides that the Council of State, if has declared by resolution supported not less than by two-thirds members present and voting any resolution in national interest, and as under Clause 2, and such resolution, if passed, it would continue for a period of 1 year, and it may continue further 1 year. And now we'll go to the very provision under Article 253 of the Constitution, and that is relating to international law. So, the very provision under Article 253 provides that legislation for giving effect to international agreements. So, in the regards to that, the very power of Parliament has the power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement, or convention with any other country or countries or any decision made at any international conference, association, or other body. So, in that connection, would like to discuss the provisions of this power to Parliament and that regarding a leading case, and that we will discuss, that is TK Dhan Shekhar versus Union of India in 2016. The Supreme Court pronounced that Article 253, which empowers the Parliament to make any law for implementing any treaty, agreement, or convention with another country or any decision made at an international conference, etc., has to be read in conjunction with entries 10, 12, 13, and 14 of List 1, which is Union List of the 7 Schedule of the Constitution. So, in relation to that, we would like to discuss the very provisions under directive principle of state policy as provided under Article 51 relating to promotion of international peace and security. So, there the very decision as relating to Magan Bhai Ishwar Bhai Patel versus Union of India in 1969, the Supreme Court pronounced that international treaties do not automatically become part of national law. They have to be incorporated into the legal system by appropriate law. However, national courts generally interpret statutes so as to maintain harmony with rules of international law. National legislation, even if contrary of international law, has to be respected, and power to implement treaties belongs exclusive to the Union Parliament as provided under Article 253 of the Constitution. As the very provision under Article 51 of the Constitution, the state shall endeavor to promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations in the dealings of organized peoples with one another, and encourage settlement of international disputes. Why arbitration? So, in this video, we have discussed the residuary powers of legislation as exclusively provided to Parliament of India in regards to any subject which is not found place under either the concurrent list or state list, but there would be a provision which is subject to as provided under Article 246A of the Constitution dealing the power relating to goods and services tax or GST as it was inserted under Constitution 101 Amendment Act of 2016. So we have discussed the constitutionality of wealth tax, the residuary powers of legislation, and non-availability of residuary power in regards to the very disqualification of members of parliament or state legislative assemblies or state legislative councils. Also we have discussed the exclusive power of council of state or Rajya Sabha in regards to enforcing and passing any law in national interest. And so also we have discussed the provisions of Article 253 in regards to international law and their implementation, and the very power of parliament to implement international treaties, agreements or conventions, and to incorporate such provisions into the municipal law or the national law of the India as regarding the very provisions of Article 51 of the directive principles of state policy, which directs the state to promote international peace and security and to maintain just and honorable relations between nations and to foster respect for international law and treaty obligations and to encourage settlement of international disputes. Why? Arbitrations, and in regard to that, we have discussed two important leading cases. One is T.K. Dhansekar versus Union of India, decided in 2016, and another important leading case which was decided in 1969, that is Magan Bhai Ishwar Bhai Patel versus Union of India. So, in our next upcoming video, we would like to discuss the most important aspect of the Constitution which relates to the very doctrine of repugnancy. So, that very provision, doctrine of repugnancy, is provided under Article 254 of the Constitution, that we will deal in our next upcoming video.